You ever order something online, track the package as it crosses state lines, and then a driver in a van brings it to your door?
Yeah, that last leg, the van to my front door, that's the part I actually care about.
So here's the question. Does that driver do interstate work or local work?
Both? The package traveled interstate, but the driver just drove across town.
Yeah, but the Supreme Court needs to pick one or the other. The answer will determine whether millions of delivery drivers get to sue their employers in court or get forced into private arbitration instead.
And that, folks, involves bread. A lot of bread.
Welcome back to the High Court Report. Today we tackle Flowers Foods versus Brock, a case about last-mile delivery drivers, mandatory arbitration, and a legal phrase from 1925 that nobody predicted would reshape the entire American supply chain. Before we start, here's your quick reminder to please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast, and on LinkedIn for written rundown. Just search the High Court Report. All right, here's what you need to know. Oral arguments take place on Wednesday, March 25th.
The formal legal question before the court are workers who deliver locally goods that traveled in interstate commerce, but who do not transport those goods across state borders and don't interact with vehicles that cross those borders. Transportation workers engaged in foreign or interstate commerce for purposes of a Section 1 of the Federal Arbitration Act.
That's a lot of words. Let's unpack it. The Federal Arbitration Act, passed in 1925, generally forces courts to enforce arbitration agreements. Courts send you to arbitration instead of letting you sue. But Section 1 carves out an exception. The FAA does not apply to contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce.
In other words, if you fall into the foreign or interstate commerce exception, your employer can't force you into arbitration.
Right. The question this term, 100 years later, is what engaged in foreign or interstate commerce actually means. Does a driver who stays entirely within one state, delivering goods that arrive from another state, qualify?
Or does a worker need to personally cross a state line, or at least touch a vehicle that did?
That's the fight. And the answer reshapes how millions of delivery disputes get resolved nationwide.
Walk me through Brock's situation.
Flowers Foods, one of the largest commercial bakers in the country, ships baked goods from out-of-state plants to regional warehouses using third-party logistics companies. Angelo Brock owns a small corporation called Brock, Inc., which holds distribution rights for Flowers products exclusively within Colorado. Brock picks up pre-sorted goods at the Colorado warehouse, loads them into his trucks, and delivers them to Colorado retail stores.
And he never crosses a state line.
Never. His entire operation starts and ends in Colorado. Flowers' own people unloaded those interstate trucks at the warehouse before Brock ever arrived. But here's the kicker. Flowers' own internal documents describe Brock as Flowers' agent, retail stores as Flowers' customers, and Flowers as the principal. Externally, Flowers required Brock to create a shell corporation, sign a distributor agreement, and pay Flowers for the right to drive for the company at what Brock called exorbitant interest rates.
Flowers structured the relationship to look like Brock runs an independent business. And the payoff, if Brock counts as an independent contractor, Flowers avoids minimum wage laws, overtime obligations, and employment taxes. In 2022, Brock sued for wage violations under the Fair Labor Standards Act and Colorado law. Flowers immediately moved to force the case into private arbitration.
Based on the arbitration clause in that distributor agreement.
Right. The federal district court in Colorado agreed with Brock in May 2023. The 10th Circuit affirmed in November 2024. The Supreme Court granted cert in October 2025.
Why did the court take this?
3 circuits, the 1st, 9th, and 10th, ruled that last-mile drivers delivering goods still in the stream of interstate commerce qualify for the Section 1 exemption. Justice Amy Coney Barrett, back on the 7th Circuit, reached the opposite conclusion. That 4-circuit split made this a priority.
Let's get into the arguments. Flowers goes first.
Flowers' central argument, Section 1 focuses entirely on what workers themselves do, not what the goods did, not what the employer does. The phrase engaged in interstate commerce requires the worker to directly and actively participate in moving goods across borders. Brock's work starts and ends in Colorado. Full stop.
And Flowers leans on recent Supreme Court cases?
Heavily. In Southwest Airlines versus Saxon, 2022, the court held the class of workers must play a direct and necessary role in the free flow of goods across borders. In Bissonnette versus LePage Bakeries, 2024, also involving Flowers, the court said workers must actively be engaged in transportation of goods across borders. Flowers says Brock fails both tests because he never touches the vehicles crossing state lines.
Flowers compares Brock to a pizza delivery driver. Both move goods from one point in a state to another, and Flowers adds a historical argument. When Congress enacted the FAA in 1925, the existing labor schemes for seamen and railroad workers each excluded purely local, intrastate workers. The Shipping Commissioner Act covered voyages to foreign ports. The Railroad Labor Board covered interstate carriers, not local operators. Reading Section 1 to exclude local drivers tracks what Congress designed.
Now, Brock's turn. Brock's central argument, Flowers invented a requirement that appears nowhere in the FAA, nowhere in Supreme Court precedent, and nowhere in a century of case law. When Congress wrote engaged in foreign or interstate commerce in 1925, that phrase carried settled meaning. Goods shipped from one state to another remain in interstate transportation until they reach their final destination. Workers on the last leg qualify. Full stop.
And Brock has cases, scores of them. In Rearick versus Pennsylvania, 1906, the Supreme Court held that a Pennsylvania agent who picked up goods at a train station and completed last-mile delivery qualified as engaged in interstate commerce. In Hancock versus Illinois Central, 1914, a trainman hauled coal exactly 2 miles within Pennsylvania before other workers carried it out of state. His whole route stayed inside one state. The court still called him an interstate transportation worker. Brock argues his situation mirrors that trainman's exactly. Same last-mile role, same interstate freight, different century.
And then there's Flowers' own admission.
Here's the gotcha. In separate Fifth Circuit litigation decided in 2024, Flowers successfully argued its last-mile drivers do qualify as engaged in interstate commerce under the Motor Carrier Act and used that ruling to avoid paying overtime. But before the Supreme Court, Flowers argues those exact same drivers doing that exact same work are not engaged in interstate commerce under the FAA.
The same phrase, the same drivers, two completely different outcomes, depending on which answer saves Flowers more money.
And Brock dismantles the pizza driver comparison directly. Flowers itself told the Supreme Court at the certiorari stage that Brock is no restaurant delivery driver, and the sole question involves last-mile freight drivers. As a class, last-mile drivers transport goods in interstate commerce on their way to a final destination. Pizza drivers move locally cooked food from local restaurants. That food never began an interstate journey.
So, what does this actually mean for real people?
If Flowers wins, last-mile drivers across America lose their right to sue in court. FedEx drivers, UPS drivers, Amazon delivery workers, postal workers completing the final leg of a package's journey, all of them face mandatory private arbitration for any employment dispute, and arbitration favors employers. Workers win at higher rates in court, recover higher damages, and produce public precedent that protects other workers.
So, if Flowers wins, the company effectively insulates its entire labor model from judicial review. If Brock wins, every last-mile driver delivering goods that traveled interstate retains the right to sue in court. The U.S. Postal Service delivers to more than 170 million addresses 6 days a week. FedEx, DHL, UPS, Amazon Logistics, all of them face this question.
And the deeper irony, Congress created Section 1 in 1925 precisely because last-mile labor disruptions wrecked commerce. In 1919, a Teamsters strike in New York City forced an express company to embargo all shipments into the city. Bread, eggs, butter, and seafood prices spiked within a single day. Congress knew last-mile workers held enormous power over the supply chain. That's exactly why Congress exempted them.
So, what should we listen for at the Wednesday, March 25th oral arguments?
Watch for the Motor Carrier Act contradiction. Multiple justices will likely press Flowers on how the same phrase can mean one thing under the Motor Carrier Act and something different under the FAA.
And watch for line drawing questions. Flowers says the 10th Circuit's multi-factor analysis turns threshold arbitration questions into mini-trials. Brock says Flowers' touch the vehicle requirement would exempt car wash attendants at truck stops while excluding commercial freight drivers. Both sides face hard questions about where exactly the line lands.
Finally, listen for Justice Gorsuch. He wrote New Prime in 2019 and cares deeply about the historical meaning of 1925 legal terms. If he presses Flowers to identify a single source from 1925 saying, engaged in interstate commerce, required crossing a state line, and Flowers can't produce one, that exchange could signal the outcome.
Bottom line, time. Why does this case matter?
It decides whether delivery workers, the people who bring medicine, food, and consumer goods to 170 million addresses, can sue in court when employers cheat them on wages, or whether those disputes get buried in private arbitration.
Listen here for oral arguments. That's it for today's episode. If you made it this far, share this episode with one person who orders things online. I promise they care about this case. That's everyone.
That's literally everyone. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for a nearly daily rundown, and follow on YouTube to see shorts. Just search the High Court Report. And the irony of asking workers to follow us on a podcast about arbitration clauses in worker agreements, not lost on us.
We promise our follow request does not include a mandatory arbitration clause. Talk to you soon.